The next defense witness.
Thank you, Your Honor. Defense calls Dr. Stephen Laken.
Sir, do you solemnly swear the testimony you are about to give in the cause now in hearing shall be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank you. You may be seated.
Morning.
Good morning.
As you know, the microphone there projects your voice for the jury to hear it, and it also triggers the recording, which is taking place, so transcripts can be made later, if necessary. So just please use that microphone to the best of your ability.
I will.
Okay, thank you. And in a loud, clear voice, could you introduce yourself to the jury, say your name and spell your last name for the record?
Good morning. My name is Stephen Laken, S-T-E-V-E-N, Laken, L-A-K-E-N, and I have a PhD in cell and molecular medicine from Johns Hopkins.
Okay, and so that's why I refer to you as Dr. Laken, correct?
Yes.
Dr. Laken, in addition to that PhD, could you summarize basically for the jury your educational background?
Yes, I earned my Bachelor's of Science degree from the University of Minnesota in genetics and cell biology. I worked as a technician for a year. I was accepted into graduate school at Johns Hopkins Medical School. I worked on my PhD for 5 years. I earned a great degree in cell and molecular medicine. My concentration was in genetics and cell biology. I then joined a company called Exact Sciences, which helped commercialize an FDA-cleared colorectal cancer screening test called Cologuard. And then since that time, I've been working on a number of startup companies, help consult with companies that are working on new diagnostics devices, and also do the DNA forensics work.
Okay, and so just so I'm clear, did you study at the University of Minnesota and obtain a bachelor's in genetics and cell biology?
Yes.
And did you study thereafter at Johns Hopkins School of Medicine and obtain a PhD in cellular and molecular medicine?
Yes.
Okay. And did you complete your education, graduate from Johns Hopkins in 1999?
Yes.
And been working in the private sector since then?
Yes.
And currently, what is your job?
Currently, I have a company. The company's called Cephos, spelled C-E-P-H-O-S. Since between 2007 and 2008, I started working with attorneys consulting on DNA forensic cases. Most of my work is all of my work is working on the defense side, and I've worked on around 1,300 cases, as well as a number of wrongful conviction cases.
Okay. And is it fair to say that in that area of work that you do now, frequently defense lawyers such as us give you DNA data and reports and conclusions that were generated in cases by the Massachusetts State Police Crime Lab?
It can be the Massachusetts State Police Crime Lab. It can also be private labs or other states.
Okay, and sometimes the crime lab contracts out with other laboratories to do certain types of DNA work?
Yes, that's correct.
And is it fair to say that you get all the data and do a top-to-bottom review of it to see if you spot issues?
Basically, what I do is ask for what's called the DNA case file, which is generally the lab's notes and written contemporaneous records along with the testing that gets done. I ask for those along with what's called the raw electronic data, basically the data that goes into producing a DNA profile. There may be criminalistics reports. In the cases of criminalistics reports, those are people that are basically analyzing the evidence at the crime lab, maybe taking pictures or doing certain serological testing or testing for biologic fluids. I may review some police notes and police records, and then basically I come to my own opinion and then communicate those to the attorney.
Okay, and did you undertake to do that in this case with respect to the DNA evidence that was given to you, provided to you by us relative to this case?
Yes.
And do you recall looking at DNA evidence relative to item 2-1.2.1, which was described as the handle and an exterior cap of a bottle of de-icer?
Yes.
And is it fair to say that several profiles, at least 3 profiles, were generated as a result of DNA testing done on that item?
Yes.
Okay. And you reviewed those profiles and that data to see if you identified any errors, correct?
Correct.
And did not?
Correct.
Okay. And there was also DNA data and materials presented to you in connection with item 2-2.2.1, which was described as the sample of exterior Powerade bottle.
Yes.
And similarly, this sample, what was presented to you is there was a number of profiles, at least 3 profiles generated in connection with that, right?
That's correct.
And you did a review top to bottom to see if there were any issues with those profiles.
Yes.
Fair to say didn't identify any.
Correct.
Not challenging those.
Correct.
And then there was the a third item that I would draw your attention to, which is 2-2.3.1, which was described as the sample of mouth of interior cap of the Powerade bottle, right?
Yes.
And again, that had at least 2 DNA profiles, right?
Yes.
And you looked at the data behind that to see if there were any issues that you disagreed with in terms of those generating those profiles, right?
Yes.
And you did not.
I did not find any issues.
Now, so the profiles are not necessarily an issue that you're here to testify about, right?
That's correct.
You looked at them, but that's not what you're here to talk about.
Yes.
What we want to ask you here today is about, well, how does DNA get from a person to an item?
There are 2 different types of DNA transfers that are generally referred to in the field. One is called primary transfer. So primary transfer is when I'm touching or handling an object. For example, if I pick up my notebook here, I handle and touch my handle this notebook, then I'm leaving the DNA potentially from my hands onto that notebook. A primary transfer, my DNA notebook. Now, when I walked into the courtroom, I opened up the door. It's possible that in the process of opening up the door, I collected somebody else's DNA who opened up the door before me, and that DNA may be on my hands. That would be a case of secondary transfer. Their DNA went through, for example, the doorknob, and then I picked up that doorknob, or I picked up the DNA from the doorknob or the door handle, and then have transferred that, or it's on my hands. So DNA can get transferred multiple times. It can be left on objects for quite a long period of time before it degrades away and disappears.
Okay. So primarily, direct contact is one way where you touch something, right?
Correct.
And secondary transfer is another common way, right?
Is another way that I can pick up somebody else's DNA inadvertently and transfer their DNA or handle their DNA.
In primary direct contact cases, DNA exists in what form in terms of cells, saliva, other ways that it would be transferred?
We're constantly shedding our DNA. Most of the way that we shed our DNA is through a process of skin cells or the cells that are on my face. We can also transfer DNA through the process of talking. In fact, when we're talking or sneezing, as the case may be, we also may transfer a lot of our DNA externally that way. So, for example, in the laboratory, to take precautions to prevent me from leaving DNA on objects that are being tested, wear a face mask to basically prevent any DNA if I cough or I sneeze, or even in the process of talking, I may be leaving and spreading DNA from my mouth. I wear basically gloves, and the gloves are to prevent my DNA from my hands being transferred to any object. And the sleeves in the laboratory are a little bit different than a common lab coat that's worn. The lab coat that's worn, the sleeves have cuffs that are relatively large, and those cuffs are basically meant to go across my wrist. And then when I wear gloves, I can put those gloves and overlap those gloves on my wrist so that there's actually no gap between the gloves and my lab coat such that DNA may be dropping down on top of things. I also wear a hairnet, and the hairnet or a beard net are those to basically prevent DNA from my hair or the skin on my hair from shedding off and landing in tubes.
Okay. So is it fair to say that a DNA analyst or scientist, when they detect DNA present on an item, that's not the same as detecting when and where or how that DNA got on the item?
That's correct.
All right. And when and where and how is really outside the scope of the DNA expert's abilities, right?
That is correct.
You're looking at profiles. It's there, or it isn't there, or there's a percentage chance that it's there. A statistical chance.
So yes, that's absolutely true. The statistical chance is when we see a profile, what's the chance of finding a profile that's similar to that in the population, not the chance of finding a profile left on that item.
So we have, as an exhibit in this case, a Powerade bottle, which is identified as Exhibit 30 here. So if I'm following what you said correctly, one way that DNA can get onto this bottle is through sort of a direct handle touch primary transfer. Is that right?
Yes.
And a second way could be if the person who's doing that direct touch of the bottle also has DNA of someone else that they have picked up somewhere along the way, right?
Yes.
Either directly from having contact with that person, right?
Yes.
Or sharing a bed with them,
Yes.
or touching a door handle,
Yes.
or just living in the same home.
Yes.
Okay. And is a third way that possibly this surface here that I've been using could have my DNA on it, right?
Yes.
Might or it might not, right?
That's correct.
This surface has been here a long time. It could have other DNA on it, right?
Yes.
Okay. And is it possible that if an item is placed on this surface, that there could even be a transfer that way?
It's possible, yes.
Okay. All right. Thank you very much, Doctor. I have no further questions.
You're welcome.
Ms. Strasnik?
If I may just have a moment to grab a couple exhibits.
Yes, you may.
Thank you.
Want me to find it for you?
While he's looking for the one exhibit I can't seem to find.
Sorry about that.
Good morning, Dr. Laken.
Good morning.
You reviewed the work that was generated by the Massachusetts State Police Crime Lab in this case, right?
Yes.
And you'd agree with me that they're an accredited lab?
Yes.
Their analysts pass proficiency and competency tests, right?
Yes.
And it's your opinion that the Massachusetts State Police Crime Lab is one of the best that you have observed?
Yes.
And you've had many opportunities to actually go to the lab and make observations of them conducting various types of DNA testing, right?
Yes.
All the things that you just described to the jury that's important to protect the integrity of testing, such as the gloves, the mask, the hairnets,
Yes.
the coats, they do all those things, right?
Yes.
And you've observed that, right?
Yes.
You'd agree with me that you're not a DNA analyst, right?
I'm not a DNA analyst.
You're not a forensic scientist, right?
I'm not a forensic scientist.
In fact, as you stated, you're a defense DNA expert, right?
I wouldn't say that I'm a defense DNA expert, but I am a DNA expert, yes.
How many times have you testified for the Commonwealth?
I have not been asked by the Commonwealth to testify, but I'd be happy to. And so
How many times have you testified for the defense?
probably around 60 or 70 times.
And how many cases have you done work for the defense as a DNA consultant?
I have about 1,300 cases.
And it's fair to say that being a DNA expert for the defense has become quite lucrative to you, hasn't it?
It pays bills, yes.
In fact, in 2026, the fiscal year, you've made over $200,000 just for Massachusetts cases where you've been retained as a defense expert, correct?
My company has billed that, yes.
And between you personally, because you used to charge personally and then you changed it to CFOs, is that how you say it?
Cephos.
CFOs for the billing. And during the course of your time as a DNA expert with Massachusetts, you made approximately $2 million doing DNA cases for the defense, right?
Yes, I've been doing this since 2008, correct?
I didn't hear the witness's answer.
Yes, I've been doing this since about 2008.
2008.
2008, yeah.
So we talked a little bit about secondary transfer and direct or primary transfer, right?
Yes,
And that's what I want to talk to you about. Secondary transfer, you said DNA gets on an item indirectly through another person or object rather than direct contact, right?
yes,
So some type of casual contact from the environment in which someone or something is, right?
it could be casual, yes.
Are you familiar with how blood is taken at a hospital or at a medical provider where it's put in vials, right?
Yes, I've taken blood samples as well for DNA.
Okay, so perfect. You're familiar with that. You put the blood into a plastic or glass vial, right?
That's correct, yes.
And if I were to shake your hand and I touch the vial, you're saying it's possible that your DNA might be on the outside of that vial, right?
Can you rephrase? Can you just ask that question again? I'm
Yeah,
sorry.
sure. So if there's blood in a vial,
Yes,
I've shaken your hand, and then
Yes.
I touch that vial,
Yes.
you're saying it's possible that your DNA would end up on the exterior of that vial.
you and I shake hands and you touch the vial. It's possible that my DNA from your hands could end up on that vial, yes.
And you use the word possible, and I think you also use the word may, but you don't know.
When DNA ends up on an object, it's not possible to tell how that DNA or when that DNA ended up on an object. That's
So
correct.
It's possible, but not probable, right?
I don't, I wouldn't give a probability of it because there's no probability statement that can be made from that. So statistically,
You don't know.
it's not possible to come up with a statistical
And
statement.
you'd agree, no matter whether it was your DNA possibly on it or my DNA possibly on the outside of that tube, neither of our DNA is going to be inside that tube, right?
That is correct.
I want to talk to you about direct transfer. DNA can also be transferred directly, right?
Yes.
For example, if I hold the handle of a firearm and shoot someone, my DNA could be on the handle of the firearm, right?
Yes.
If I hold a bottle, my DNA could be on that bottle, right?
Yes.
Are you familiar with buccal swabs?
Buccal swabs, yes.
Where are they taken from?
The buccal swabs, the cells inside the mouth are called buccal cells. And so a buccal swab is basically the passing of a cotton tip or cotton swab over the outside of the cells in the mouth.
And it's taken from the mouth because it's the easiest and cleanest and most reliable source of DNA, right?
I wouldn't say the most reliable source, but I would say that it's an easy source to take samples from, yes.
Well, isn't the inner cheek and the mouth lined with epithelial or skin cells that are constantly shedding?
They are, however, in the process of doing things like kissing or sharing drinks, it's possible that one could end up with DNA from somebody else in their mouth. I would say when you say the most likely source or the cleanest source would probably be blood, because people can't really change their blood and it doesn't mix, and it's a very good source of cells. So I think blood is a better source, but it's not often taken because it requires Venipuncture, there's some safety issues in terms of personal protection.
But you'd agree that swabbing of the mouth provides DNA that has both skin and saliva, right?
I don't think that the mouth has skin cells in there. I hope it doesn't have skin cells.
It doesn't have epithelial cells that are shedding constantly?
Epithelial cells are different than skin cells. So epithelial cells are basically cells that are on the exterior of organs. So skin cells, for example, would be epithelial cells. Buccal cells would be epithelial cells. So yes, the mouth does have epithelial cells, just not skin cells.
I want to talk to you about Exhibit 30. Attorney Scully asked you some questions about this item, right? 20. Exhibit 20.
Yes.
You know what that is?
It's a Powerade bottle with a cap.
You'd agree with me that to drink from that bottle, you have to remove the cap, right?
Yes.
And the mouth of the bottle is inside of that cap, right?
Yes.
Could you remove the cap?
Yes.
You'd agree with me that the inside of the cap isn't exposed until you just remove that cap, right?
That is correct, yes.
The area is covered when the cap is closed, right?
Yes, ma'am.
It's not exposed to the casual contact of the environment unless that cap is removed, right?
Yes.
Someone wouldn't touch that area unless they opened it, right?
Yes.
You'd agree with me that not only does the cap of a bottle prevent spilling, but it also protects the area of the bottle you drink from, right?
Yes.
You'd agree that it acts as a barrier between the outside world and the drinking surface.
Yes.
To drink from that bottle, a person would need to place their mouth on the opening, correct?
Yes.
Their lips would make direct contact with the rim,
Yes.
and that's how most people drink from a bottle, correct?
Yes.
So the mouth of the bottle is in the exact area someone's lips would touch when they're drinking it.
Yes.
So finding DNA there is consistent with someone drinking from that bottle, right?
It may be consistent with that, yes.
You said that you agreed with the results of the Massachusetts State Police Crime Laboratory in terms of their DNA analysis and their statistics, correct?
Yes.
I'm going to show you what's been marked as Exhibit 61. So you agreed that the DNA of Leroy Fowler was 9.96 trillion in favor of his DNA being present on the exterior of the Powerade bottle, right?
The statistical statement you gave needs to be read in full. I'm happy to read the statistical statement. I don't disagree with the Commonwealth's report.
So you agree with the statistics, and this is a large amount of DNA that was present, correct?
It was not a large amount of DNA present.
It was a full profile, right?
It was a full profile, yes.
And you agreed that Barbara Randall was excluded from any part of that bottle, right?
I do.
I have no further questions.
Mr. Scully.
No further questions. Thank you very much.
Thank you very much, Dr. Laken. You may step down.
Thank you. Thank you. Your Honor, do you want me to?
You can just leave that right there. Thank you, sir. Does the defense rest?
Judge, defense would move.
Oh, I'm sorry. You go ahead, Mr. Scully.
Thank you, Your Honor. Defense would move in the next exhibit. I believe there's no objection. This is the deed to the property in Florida, and I'm looking for the address at 3965 East Lake Park Drive, Hernando, Florida, owned by Judy Church and
All right, then that may be admitted as our next exhibit. I take it there was no objection?
no objection.
Exhibit 67, so marked.
And with the court's permission, may I
Read some medical experts.
publish this to the jury
Oh,
briefly?
yes, you may.
So this is Exhibit 67 on the screen. Thank you, Your Honor. And lastly, with the court's permission, we have several entries from medical records of Mr. Fowler we'd like to read to the jury.
Yes, you may. Jurors, yesterday, just as I allowed Mr. Camilio on behalf of the Commonwealth to read a few excerpts of some notebook entries, all of which are part of the evidence in this case, have been admitted as exhibits and are available for you to review. I'm going to permit Mr. Scully to highlight a few passages in medical records that have been admitted as exhibits, are available in full for your review, but he's going to read a few passages, and I think in each instance he'll identify the medical record and the date. Go ahead,
Yes,
Mr.
I
Scully.
will. Thank you, Your Honor. These are all from Exhibit 8.
Also, non-dramatic reading by Mr. Scully.
Best I can, Judge. Thank you. So from Coastal Medical Associates, Leroy Fowler, November 13th, 2015.
Would you tell me that date one more time, Mr. Scully?
November 13th, 2015.
Thank you.
Anxiety, chronic problem, insomnia, chronic problem. From Coastal Medical on April 28th, 2017. Abdominal pain of unknown cause. From Coastal Medical on July 11, 2018. Past medical history, depression. From Coastal Medical, August 27th, 2019. Treatment number 6, bipolar 1 disorder. September 30th, 2020, Coastal Medical. Assessment, hypertension due to drugs. And lastly, from June 13th, 2022, Dr. Shane, Office of Dr. Shane Murray, history, chronic lower back pain, abdominal pain, impression, moderate constipation. Thank you, Your Honor.
Thank you. And with that, Mr. Scully, does the defense rest?
Bench rest.
Thank you. Jurors, we are going to take a recess. We'll allow the attorneys to collect their thoughts. And when we reconvene in about 20 minutes, we will proceed to some preliminary or pre-closing instructions by me, and the closing arguments, and some additional instructions by me, and then deliberations will begin. So we're going to take that break right now, give counsel, as I say, a chance to collect their thoughts and get ready for the court.
All right.
Court is back in session. May be seated.
Thank you. Mr. Scully, you have a motion.
Yes, Judge, may I approach?
Yes, you may.
I think I printed this the other day, so it says 326, but. But I am happy to make argument, but also waive argument at this time.
All right. Thank you, Mr. Scully. The motion for a directed verdict has been renewed at the close of all the evidence. I do not find that the Commonwealth's case, viewed in the light most favorable to the Commonwealth by the jury, has degraded through the presentation of the defense case to the point where it changes the determination that I previously made, which is that the evidence is sufficient, construed in the light most favorable to the Commonwealth, to satisfy beyond a reasonable doubt the elements of the charged offense of first-degree murder on both theories. And so I therefore deny the renewed motion, and we'll take that recess of 20 minutes or so, and then we'll reconvene for instructions and closings.
Thank you.
Thank you all.
Court, all rise. Judge, I'm sorry, before we go, one thing.
Yes.
At the beginning of the trial, there had been some discussion about expert testimony that ethylene glycol could be a substitute for cocaine or used for various things by a cocaine addict. None of that came in during the course of the trial, so I would just ask that the court instruct the defense that they cannot argue that in the closing.
Mr. Norkunas?
Judge, I think the medical records are full of, he has polysubstance abuse from both tobacco and cocaine, or within each of the three medical records. They're also in his own personal medical records, which are all now exhibits within this issue here. I don't think that I was going to rely significantly on that, but I think that my memory is testimony did come in from several of the civilian witnesses about his cocaine use in here, I believe. I think it was Mr. Hawkins, if I'm not mistaken, had talked about it.
There's certainly evidence. There's evidence about Mr. Fowler's cocaine use. Mr. Camillo is correct to my recollection, and I was listening for it. I didn't hear any competent medical or toxicological testimony by any witness that, for example, someone in the throes of cocaine withdrawal, if they have a substantial substance use disorder with respect to cocaine, might seek out ethylene glycol and intentionally ingest it. We had that discussion during the motions in limine, where I made plain that I would not permit that to be argued unless competent supporting testimony was presented so that the jury would have a basis for drawing such an inference. It has not been presented, so I won't permit that argument. That is that the jury might find that Mr. Fowler would have intentionally ingested a mixture, a drink of some kind with ethylene glycol because he was experiencing some sort of cocaine withdrawal. That's not permissible because there's no supporting evidence.
I don't intend to make that type of statement, Judge. My statement that's in my notes here would be, he's at one of the most climactic moments of his life. The medical records show you that he suffers from depression, he's bipolar, he has polysubstance abuse, he has a pacemaker. The hospitals indicate that also his use of cocaine and cigarettes are a concern.
That's all evidence before the jury. I don't have an issue with you saying those things.
It's not my, and that's the position.
Mr. Camillo just wants to make sure that you're not taking that one step further, because if you did, he'd have to object. I'd have to strike it, which is, just as I've just said, which is to suggest to the jury, someone like Mr. Fowler, who may have been abusing cocaine, you might find would have sought out ethylene glycol. There's no basis for the jury to draw such an inference because there's no supporting medical testimony of any kind that people who may be cocaine users do such things.
I'm not going to say what other people knew. I'm going to say what condition he was in. One of the most climactic moments in his life. He's at the hospital and he has EG. There's testimony from many witnesses that have said people on their own do consume ethylene glycol. I think Mr. Camillo just asked Mr. Crouch about that.
You may argue anything that's in evidence, and in the fair inferences from the evidence that doesn't require some expert testimony that hasn't been adduced or presented. So, I'm not going to micromanage the closings. This was one particular issue of concern to Mr. Camilio. You're not going there, and that's fine. Thank you all. So we'll be in recess, and then we'll reconvene.
Court, all rise. Court will stand in recess.